Good afternoon, folks. Today we're going to cover the 1 to 4 family residential contract, the first 5 paragraphs, paragraph 1 through 5. So let's just jump right into this. So before we get into the meat and potatoes of the contract, I want to point out a couple of things that you need to be aware of when writing contracts here in the state of Texas. The very first thing you should notice is at the very top of this contract on the right side, you will see a date. It's February 12th, 2018. That is the effective date of the most recent contracts that we have, and that is the date showing the most recent contract, which is always what you will use when writing a contract here in Texas. You cannot use outdated contracts. That is a violation of TREC rules. So that's the first thing you need to notice. Make sure you're using the appropriate contract. The second thing you'll notice is the title of this particular contract. It is the 1 to 4 family residential contract resale. That means this contract is going to be used for anything from a single family residence, one single dwelling, all the way up to a fourplex and everything in between. A duplex, triplex, 1 through 4 is considered residential, and this is the contract that you will use covering those particular types of units. The other thing you'll notice is at the very top underneath the title, it has a section that states that it is not for use for condominium transactions. That is because in the state of Texas, we have a promulgated form just for condo contracts. So that being said, as long as you're using the most updated contract and it is a 1 to 4 family residential unit and it's not a condo, this is the appropriate contract. So let's jump right into the first paragraph of this one. It's probably the simplest one. So the parties to the contract. So paragraph 1 covers the parties. Now this is basically the seller and the buyer. And you list the seller first. So the parties to this contract are the seller. Now a seller can be the name of a person or persons. It can be a LLC, a trust, corporation, or any other legal entity that exists in the state of Texas. And the next blank is the buyer. Now the buyer can also be an individual or individuals, can be a legal entity in the state of Texas. And oftentimes when you are working with an investor who may attempt to assign this contract to another buyer, it may have the buyer's name and then the phrase and or assigns. So, or assignees, I should say. And if you have that in your contract or somebody submits a contract like that, you should be aware that they may at some point try to turn around and wholesale or provide that contract to somebody else. And so just be aware that may be what you're dealing with should that pop up on your contracts. States seller agrees to sell and convey to buyer, and buyer agrees to buy from seller the property defined below. And that completes the first paragraph. It's pretty self-explanatory. If you have any questions, feel free to post them below on that, and we will go over them. The next paragraph defines the property. So we have who's buying, who's selling. Now we need to define the property. So the very first part of this states that the land, improvements, and accessories are collectively referred to as the property. So you have to remember, when you talk about property, you have 2 things. Actually, you have 3 things. You have the land, you have the improvements to that land, and you have accessories that are a part of those improvements that will convey with everything, and together they are the property. So let's go through this paragraph, each subsection. So 2A describes the land. Now it has an area for you to list the lot, all right, which may be lot 36, lot 42, lot 36B, or it could be a variety of, but it's usually a number. And then you have a place to list the block. The block can be a number, can be a letter, can be 2 letters, 2 numbers. When you subdivide property in an area, usually you'll have a block, and then you'll have a lot within that block. And then you'll have a legal description, and that legal description usually relates to the name of the subdivision. So for example, this past summer, I had a seller who subdivided a piece of property, actually 3 pieces of property they owned, into 2. And so the name of that subdivision was the First Baptist Church of Bastrop subdivision. And so typically you will have some type of legal description that you'll be able to find on the county record, and that will go into that 3rd blank spot. All right. If it's inside a city, you will list the city name. If there is no city attached to it, you will just go ahead and put NA, although almost all properties reside in some type of city for the purposes of addressing. The next blank will be the county. So if it's, whatever county it's in, you'll go ahead and list that. It has that it's in Texas because these are Texas specific contracts. And then the final blank in 2A is going to be the common address for the property. 123 Main Street would be a common reference for a property. So you have 123 Main Street and just the zip code. You don't have to put the city or the state. That's already there. So it's just the address and the zip code. Now, perhaps you have a legal description that just doesn't fit in this framework. It's very long, or it's just made up of a lot of different parts. So if you cannot fit it in here, it doesn't work. You'll see that there's a little catch-all on the very end of this particular section that says, or as described on attached exhibit. So should you have to attach an exhibit because your legal name just does not work here, you can go ahead and do that, and then just make sure you write somewhere in this 2A section, see exhibit, and then make sure you reference the exhibit, either number 1 or number 2 if there's multiple ones. Should be number 1 though, because this is the very first part of the contract. So at this point, we've identified the land. Now we need to go on to 2B, which is to describe the improvements to that land. So we'll read through this and we'll talk a little bit about each part. So the improvements include the house, garage, and all other fixtures and improvements attached to the above described real property, including without limitation the following permanently installed and built-in items, if any. So let's talk a little bit about what it means to be permanently installed and built in. All right. So if you have to cut it, unscrew, and when I say screw, I mean you've screwed it into the wall. For example, if you've screwed something like what do you want to call it? A cabinet. So you put up a cabinet and you screwed that cabinet into the wall. If you have something around your fireplace and you've screwed that in there, anything that you've screwed into the thing that you have to unscrew or unbolt, that would be considered permanently installed and built in. If you have to, like I said, cut it, cut something to get it out, that would be permanently installed, built in. If it is permanently attached or designed for that property and you cannot easily just, take a pic, like taking a picture off the wall or unplugging something and walking away with it, it is considered permanently installed and built in. My favorite example of this is a refrigerator. So a refrigerator is a piece of personal property. It is not normally considered permanently installed or built in. That being said, in some custom homes, they will build cabinetry in the kitchen around a refrigerator, where the only way to get that refrigerator out is to either cut apart or cut into or remove sections of cabinetry in order to be able to pull the fridge out. If that's the case, that fridge is considered permanently installed and built in, because you have to, again, unscrew or unbolt or cut into something just to get it out. And so that would be a really good example of something that's personal property that becomes permanently installed and built in based on the way you set it into the cabinetry. So hopefully that provides some explanation on what it means to be permanently installed and built in. So let's go ahead and address some of these things. All equipment and appliances. So any equipment or appliances that are permanently installed. So if you have a pool pump, for example, and that pool pump is, the pipes come out of the ground and the pump and everything is secured to that, and in order to get that pump and take it away, you'd have to cut those pipes. That would be permanently installed. All right. So all equipment and appliances, valances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, attic fans, mailboxes, television antennas, mounts and brackets for television speakers, heating and air conditioning units, security and fire detection equipment, wiring, plumbing and light fixtures, chandeliers, water softener systems, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, outdoor cooking equipment, and all other property owned by the seller and attached to the above described real property. All of those things are considered, if they're permanently installed and built in, must stay with the property. Period. All the ceiling fans, okay, they have to stay. You can't just change them out during the contract unless the buyer signs off on it. All right. Plumbing and lighting fixtures. All right. So your stoves that are, gas stoves, water heaters, stuff like that, all have to stay. You can't just trade those out for something different once you go under contract. Water softeners are a big one. If it's a water softener and it's permanently installed, which they almost always are, that stays. All right, even if it's leased, if you don't exclude it, which we'll talk about in a moment, it has to stay. And what will happen is the seller will end up having to pay it off because they can't take it with them. All right. So again, all these things have to stay if they are permanently installed and built in. 2C talks about accessories. These are things that are not necessarily permanently installed and built in, but are a part of the property, and so they will stay. All right. So the following describe related accessories, if any: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, draperies and rods, door keys, mailbox keys, above ground pools, swimming pool equipment and maintenance accessories, artificial fireplace logs, and controls for garage doors, entry gates, and other improvements and accessories. So this would be an example of things that are not permanently installed or built in, but they are considered accessories and must remain with the property. Window air conditioning units are ones where sellers will oftentimes take window air conditioning units, but those are required to stay unless they are excluded. Drapes and rods and curtains are another one that sellers will oftentimes take. So make sure that your sellers understand they cannot take curtains, they cannot take the rods, blinds, window shades, draperies, all that stuff must stay unless they exclude it. So let's talk a little bit about exclusions. So 2D is where you will find the exclusion section. So it states the following improvements and accessories will be retained by seller and must be removed prior to delivery of possession. All right. So if your client wants to keep something above that's referenced in either 2B or 2C and they want to keep it, it must be provided in 2D. So this could be your curtains, this could be your rods, this could be a really expensive built-in refrigerator, as I used in the example previously, but they still want to keep it, and so they go ahead and exclude it there in 2D. If it's not excluded in 2D and it's listed in 2B or 2C, it has to stay. That's just the way it is. If you do this long enough, at some point you may make a mistake, and this is where we say, you'll end up buying your client some curtains, or you'll end up buying your client an appliance or some other piece of equipment that you didn't clarify that they couldn't take with them and they took anyway, and then in order to make it right, you have to step up and purchase that for somebody to keep everybody happy. 2E, reservations, states that any reservation for oil, gas, or other minerals, water, timber, or other interests is made in accordance with an attached addendum. If your clients want to reserve mineral rights, your sellers want to maintain or reserve their mineral rights, they must do so in a mineral rights addendum, which will be discussed in a different video. That is the only way that they may maintain mineral rights or reserve their mineral rights, if they should have ownership in those. All right. Again, if you have any questions about paragraph 2, go ahead and post them below and we'll get them addressed the best we can. Paragraph 3 talks about the sales price. So the very first line, 3A, is where you will list the portion of the deal that will be paid in cash. This is often referred to as their down payment. Pretty self-explanatory there. You'll get with the lender. You will explain to them, or not explain to them, but they will explain to you, how much money the client's putting down. That amount of money goes in that first blank. The second portion, 3B, states the sum of all financing described in the attached, and you get to list whether there's a third-party financing addendum, a loan assumption addendum, or a seller financing addendum, all three of which will be discussed in a later video. Together, those will make up the sales price. So 3C should be the sales price, and that should 3A and 3B should equal 3C. If it's a cash deal, then 3A will list the sales price, though it will be a 0 in 3B, and 3C again will be the sales price. And so that's kind of how that math matches up. That's also fairly self-explanatory. The only thing I'll notate here though is that you need to make sure and select the appropriate addendum that you're using for the financing, and that is something we will discuss in future videos. Number 4, license holder disclosure. I'm going to read it and then we'll discuss it. Texas law requires a real estate license holder who is a party to a transaction or acting on behalf of a spouse, parent, child, business entity in which the license holder owns more than 10%, or a trust for which the license holder acts as a trustee, or of which the license holder or the license holder's spouse, parent, or child is a beneficiary, to notify the other party in writing before entering into a contract for a sale. Disclose if applicable. So, the state of Texas states that if you're representing somebody that you're related to, either a spouse, a parent, a child, or if it's a business in which you own more than 10%, or a trust in which any of the aforementioned benefit from that trust, you have to notify the person on the other side of the transaction that you have that relationship. So in this blank, it's not very clear what they expect you to write in here, but you do need to make some disclosure. I will usually state something as, buyer's agent or listing agent is related or has affiliation with the seller or buyer, depending on which one is applicable. I would encourage you, if you have any financial interest whatsoever in one of the principals, one of the parties to the transaction, that you disclose either way. So for example, if your spouse owns a company which you don't technically have any ownership of, because you could have zero ownership except through, the fact that we are, what do you call it? A common law, not a common law state. I'm sorry. All your assets held in a marriage are jointly held together. So even if you don't technically have ownership on paper, if you benefit financially from that, you probably want to disclose even if you don't technically have any ownership in the business. So if you have a financial interest, I would disclose in section 4. This is a TREC rule. All right, it's a rule inside of Trella as well. So not disclosing in and of itself is a violation. So please don't get caught working for a family member or for yourself or an entity that you benefit from and not disclosing that. Paragraph 5 is where we start to get into the terms of the contract. So paragraph 5 deals with earnest money. So let's just read through it and then we'll go back and we'll review. Within 3 days after the effective date, buyer must deliver X number of dollars as earnest money to blank as escrow agent at another blank, which is supposed to be an address. Buyer shall deliver additional earnest money of blank dollars to escrow agent within a blank number of days after the effective date of this contract. If buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to buyer before buyer delivers the earnest money. If the last day to deliver the earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. And then in bold print, time is of the essence for this paragraph. So let's break this down a little bit. So this earnest money has to be delivered within 3 days. It is not 3 business days, it is 3 calendar days. So 3 calendar days is when that money has to be delivered. Now, 3 calendar days, buyer must deliver a X amount of dollars. Now, you can put, or I should say the buyer can put whatever amount of money in earnest money that makes them feel comfortable. I would say it is typical across all markets in the state of Texas to have a 1% of sales price earnest money amount. That is what we typically see. That being said, there's nothing that requires that. It could be more if it's a multiple offer situation. It could be less if the buyer just doesn't have it or doesn't want to put up 1%. Whatever amount the buyer is okay with, but I would say that the averages that we see are 1% across all markets in the state of Texas. So they have to deliver that amount of earnest money to, and you have a blank and it says escrow agent. there has been some debate in the past. This is the name of a person. The escrow agent is whatever escrow officer you are working with at the title company. It is not a title company name. You'll see in some other parts of the contract that it is differentiated between escrow agent, title company, and so on and so forth. So there's some other areas where it differentiates. So this is the name of a person who you're going to be working with, the escrow officer that's going to be handling the file. And it's whatever their place of business is, so you'll put that address in there. Wherever you deliver that money to, that's where it's going to be. So the next portion says, buyer shall deliver additional earnest money of blank. So if you're going to have an initial amount of earnest money, and then a certain number of days later you're going to have additional earnest money, this is where you would place that. So if they're going to deposit an extra 1% of earnest money, within 7 days after the effective date of this contract, so maybe they're going to break it up a little bit, or maybe they're in a multiple offer, so they want to make sure they secure it before they deliver extra money. However you want to do that, that section there allows for it. If the buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to the buyer before buyer delivers the earnest money. So if the buyer does not deliver their earnest money within 3 days, that gives the seller the ability to unilaterally terminate the contract or exercise their remedies under paragraph 15 by providing them notice. Now, if the buyer doesn't provide the earnest money within 3 calendar days, all right, and let's say they wait till the 4th day and they deliver it on the 4th day, that's still okay. The only thing that this new section does is it allows the seller to unilaterally terminate. So for example, let's say that the buyer doesn't deliver earnest money within those 3 days, and on the 4th day in the afternoon, the seller says, you know what, go ahead and terminate this contract tomorrow morning. I don't want to mess with this. Let's just do it. And you say, okay, Mr. Seller, we're going to do that. Well, if that evening on the 4th day at 4:59 p.m. that buyer drops off their earnest money at the title company prior to your seller sending a termination, your seller loses the ability to unilaterally terminate on the beginning of the 5th day. All right, so it's kind of, after the 3 days passes, it's kind of a race to see who does what first. Does the buyer turn in their their earnest money, or does the seller terminate the contract unilaterally? Either way, it's going to be based on timing, and there are no time limits on this particular paragraph. It's not like the option period where it ends at 5 p.m. Or anything like that. Now, that being said, most title companies close around 5 p.m., 6 p.m., and so if you missed that time frame and the termination comes in after hours, it would still be applicable. So while there's no time limit inside of the contract, there is a functional time limit because the title company will close and you won't be able to deliver your earnest money after 5 or 6 p.m., but a termination from the seller could still be sent after hours and would still be applicable. Now, if the last day to deliver the earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. So, if you execute, for example, a contract on Thursday, well, you have Friday and Saturday, and the earnest money on the 3rd day would technically be due Sunday, then it automatically rolls to the next day, and it would be due on that 4th day, which is the Monday. Now, if Monday was a legal holiday, for example, then it would roll till Tuesday, and they would have Tuesday till Tuesday to deliver that earnest money. But if you go under contract on a Monday, earnest money is going to be due on a Thursday, because Tuesday is the 1st day, Wednesday is the 2nd day, and Thursday is the 3rd day. If you were to go under contract, for example, on Friday, your earnest money will still be due on Monday, because Saturday would have been the 1st day, Sunday would have been the 2nd day, and Monday would have been that 3rd day. So keep that in mind. They are calendar days, not business days, but if the 3rd day does land on a Saturday, Sunday, or legal holiday, then it bumps forward to the next day. And the final thing I want you to take note of is that in nice big bold print it says time is of the essence for this paragraph. There are a handful of time is of the essence provisions within our contracts, meaning that time is of the absolute most importance. If you miss it, even by a minute, or somebody gets something in there even a minute before you, it can be the difference between being under contract and not being under contract, fulfilling your requirements or not fulfilling your requirements. That's all I have today for the 1 to 4 family residential contract. We're at about 25 minutes. Paragraph 6 is going to be its own video because it's so long, so we're going to stop just short of that one. Look for that one to come out in the near future. You guys have a great day. Thanks for listening. Please let me know if you have any questions by posting below. Thanks.